Good afternoon, everyone, and welcome to AFME's webinar on the use of the Section 3C7 exemption under the U.S. Investment Company Act. We'll speak today about the 5 firms memo that was originally negotiated by AFME with a few prominent law firms in 2008 and updated in 2012, and how these procedures outlined in the memo are a good guide for increasing the chance of complying with the exemption. We'll also speak about relevant market developments since the memo was drafted, current market practice, and we'll discuss how and whether the market is still adhering to the principles contained in the memo. We'll also speak a bit more briefly about relevant ERISA and Investment Advisor Act issues before taking any audience questions during a Q&A session at the end. And even though that session is at the end, you can ask questions at any time through the Q&A function on your screen. We'll get started right away by asking the panelists to introduce themselves, and then we'll begin the program. Peter, can you start?
Yeah, Peter Castellan. I'm a partner at the London office of Proskauer. At the time of the 5 firms memo in 2012, I was in-house at Citigroup here in London.
Jonathan?
Hello, everyone. My name is Jonathan Baird. I'm a corporate partner in the London office of Hogan Lovells. And as with Peter, I've been involved in investment company offerings now in London for some time.
Sebastian, go ahead. Sebastian, I think you're on mute.
Yeah, a very novice mistake there. Sorry, Gary. Sebastian Sperber, partner at Cleary Gottlieb Steen and Hamilton, work on a lot of capital markets transactions that implicate the Investment Company Act from time to time as well.
And Karen, last but not least, you were just the last person in the picture waterfall. No offense. Could you introduce yourself now quickly, please?
Hello, I'm Karen Anderberg. I'm a U.S. qualified partner in Deckert's London office in the Financial Services Group. I help UK and European clients with accessing US markets with respect to US regulations such as Investment Advisors Act, registration, CFTC, and any other questions they have about how to market funds into the United States.
Thank you, Karen. So why don't we just get started? Peter, maybe you can give us a brief history of the 5 firms memo and related Investment Company Act issues and explain why it's important that we do what we're doing today and take another look at this.
Absolutely. So the history of the 5 firms memo, I think, is an interesting one. In 2005, we had what was the beginning of a boom in European investment companies. So these are what Americans call foreign funds. So they are funds. These are not operating companies that inadvertently become investment companies. These are funds. And so 2005, 2006, there was an absolute boom in Europe on funds that were listed on European exchanges. And as with everything else, they were sold in the United States to QIBs. Now, if you have a fund, you have to look for an exemption under the 33 Act, as you always do. And that typically is Rule 144A, but could be Section 482 to QIBs, could be Regulation D. But you also have to find an exemption under the 40 Act, the U.S. Investment Company Act of 1940. And the 2 exemptions that usually jump out are 3C1 and 3C7. There are a few others, 3C5, 3C6, but 3C1 is an exemption for 100 U.S. investors, and 3C7 is an exemption for qualified purchasers. 3C7 is the one that's mostly used for public funds. And so 2005, 2006, we had an absolute boom in foreign funds going to the United States. It's hard to imagine now, but ECM professionals who in 2004 were working on industrials were now doing funds. Like there was a really significant switch for that boom. And so I was in-house at Citi at the time. We worked with a lot of great law firms representing us. That tended to go very well. We all had different procedures for taking care of qualified purchasers, making sure there were qualified purchasers. For the most part, nobody seemed to have a sense that there was anything wrong with the market as it was functioning at that time. It wasn't particularly uniform, but by and large, people knew to look out for qualified purchasers, and people had procedures in place to make sure that they were complying with the 40 Act. Completely out of the blue, from one day to the next, the 5 firms issued their 2008 memo. And the 5 firms is a group of, as the name would suggest, well, not as the name would suggest, there are actually 6 firms in the 5 firms. So there are 6 firms in New York who work on Investment Company Act issues, and their Investment Company Act partners meet regularly. And they decided at some point in early 2008 that they were going to issue a memo on procedures for foreign funds that were complying with Section 3C7. That came from the perspective of a lot of in-house lawyers in London at the time. That came completely out of the blue. There was no warning it was coming. There was no particular warning that there was anything wrong with what was going on. It was just from one day to the next, this memo appeared. And the 6 firms that constitute the 5 firms complied with it from day one. And I can see Sebastian is laughing. Not Sebastian, but at a different 5 firms, the partners in London had no idea that this was coming, and they were caught by surprise as much as the rest of us. And so the 2008 memo imposed the most conservative procedures that were going. It wasn't assessing where people were, it was the most conservative procedures were imposed on the market. Clearly, the firms that constituted the 5 firms complied with it, but a lot of other firms complied with it right away as well. And so suddenly we had these very conservative procedures imposed on us without much warning. AFME immediately went into crisis mode, and there were calls. In those days, we didn't have video conferences, it was conference calls. And so there were calls, and we got organized, and Gary's predecessor at AFME Lorraine Charlton organized a call with the 5 firms. And we had that call. There were like preparatory meetings for it. Like we wanted to have all our ducks in a row. And so the decision was made that only alumni of the 5 firms would speak on behalf of AFME. And so the investment banks in London were scoured to find managing directors who were alumni of 5 firms. There were 3 of them who took the lead at that meeting. So the idea was we wanted the 5 firms to be speaking to their own people. We didn't want them to think that these were, foreigners who didn't understand. These were the people who spoke were Americans who had been in New York and did Investment Company Act work at some level when they were in New York. And so that meeting or that conference call went badly, really badly. And we reached a stalemate, and we were not able to convince the 5 firms in any way. And so from that point onwards, the market generally imposed the conservative procedures of 2008. Now, this wasn't as big a problem as it sounded because 2008, the boom was over. And so, if this had happened in 2005, it would have been a disaster. But it happened in 2008, the boom was over. There were a few investment companies that were, still happening, still doing their deals, but it was it wasn't the same volume as it had been. And so from then onwards, we followed the conservative procedures more or less. A few exceptions here and there. including in 2011, I was working on, we at Citi had a foreign fund that was doing a follow-on offering. It was not an IPO, it was a follow-on offering. We had Sherman representing us. The foreign fund had a top New York firm that was not among the 5 firms, but still a top New York firm. The general counsel of the fund was an alumnus of a 5 firms firm. And I got a call from Sherman saying the lawyers across the table are not going to have told us they're not complying with the 2008 5 firms memo. Mm. And they seemed to think that I was going to say, oh no, let me fix it or something. And so I said, oh, that's interesting. Good for them. I wouldn't either if I had a choice. So good for them. And so there was a lot of back and forth. This other firm, again, a top New York firm, so they knew exactly what they were doing. This wasn't, oh, they didn't understand or they didn't know. They knew exactly what they were doing. And they said, no, we are not complying with it. We are going to use more liberal standards. That deal terminated for unrelated reasons. It wasn't because of the 5 firms, but it came to an end. But I used that opportunity to re-engage Sherman, one of the 5 firms, in the discussion. And so the partner at Sherman at the time was Nathan Green, one of the authors of the 2008 memo and again the 2012 memo. And the discussions with AFME were reignited through Sherman. And so Lorraine Charlton kind of established a working group to discuss with the 5 firms. So this time around, it was 4 of us who engaged in that. It wasn't the big conference call that we had before. And even then, in late 2011, early 2012, it was we were doing video conferences. One of the earliest examples of video conferences with the 5 firms. So that working party was Jonathan, me, Duncan Reed, who at the time was an in-house lawyer at Goldman Sachs, and the late Daniel Bushner, who had been a partner at Rogers and Wells, and Clifford Chance. And so this time around, the 5 firms were more willing to talk. And I think the 4 of us who were in that working group were kind of more willing to humor them than 4 years earlier when we had the AFME call and everybody was more horrified at what they were trying to impose on us. And so the general idea was we need procedures that are better tailored to the realities of listing rules in Europe and better tailored to the realities of how clearing systems work and are not dogmatic. We need an acknowledgement in the procedures that there are facts and circumstances on a deal-by-deal basis that make things different and can be handled differently depending on the circumstances. So we were more successful this time around. The 2012 5 firms memo came out. And in the early days of the memo 2012, I'd say, as far as I could tell, everybody generally accepted it, and we were in a much better place, and there was less discussion, and we got on with it. There weren't as many foreign fund IPOs at that time, 2012, 13, 14, 15. But they came back, and they're back now, and we're working on quite a few these days, both true foreign funds and also inadvertent investment companies, which are operating companies that technically become funds for U.S. purposes. And so I think that this panel is just important to remind everybody that the AFME negotiated this, and we think that it works for the European market, and that people should be conscious of it. I certainly am not advocating that people follow it dogmatically, because that was the whole point of the 2012 memo, to include more flexibility. But people should be conscious of it and should refer to it even if they do deviate, so that we have a common frame of reference and so that they know probably where the starting point is. I've encountered a few deals recently where the partners on the other side were not aware of the five firms memo, or maybe not as aware as they probably should be. They were, everybody was being conscientious and were imposing procedures, but it would have been easier if their starting point had been the five firms memo. And then, Gary, your question was, why is it important? Yeah. This is very important, because if you get it wrong, so if you have an investment company and you don't put the appropriate procedures in place, and you sell to a non-qualified purchaser, or if you're relying on 3C1, if you sell to your 101st American, then the transaction is void ab initio. All that the investor has to show is that the company was an investment company. They don't have to show reliance or anything. It's ab initio. So this is important from the point of view that if you have a foreign fund, you have to put procedures in place. And if you have an inadvertent investment company, again, you have to put procedures in place as well. So that's the importance of this. And hopefully that was a short history of how we got to where we are.
And if I can
helpful. Sorry, go ahead, Sebastian.
If I can just jump in there, Gary, and just amplify the last point that Peter made, and just maybe give the 2008 and 2012 procedures a little bit more flavor. What we're stuck with here is a statute that basically just says there's an exemption available from the Registration Company Act, from the Investment Company Act requirements, if you only sell to qualified purchasers. And other than a clause in the definition of qualified purchaser that talks about needing to have a reasonable belief that somebody's a qualified purchaser, the SEC hasn't defined a set of procedures get comfortable with all of the complications associated with that general proposition. And so the good reasoning behind the procedures was not to impose requirements on the industry, either conservative or liberal, but to actually come up with a framework that otherwise doesn't exist for how law firms and market participants can get comfortable that the exemption is being satisfied. So I think that the feeling was that in many ways the 2008 framework didn't necessarily serve everybody in a way that was comfortable for the industry. 2012, very important, because they at least show a straw man as to how one can go about getting comfortable to satisfy this exemption. Peter's right, both conservative, less conservative, more liberal. If you just use 2012 as a starting point, you at least have a reference point, which is what you don't have without something outside of the Investment Company Act itself and the rules they're under. And so where we are is we're trying as an industry together to come up with a way to sell securities and investment companies. And unlike the Securities Act of 1933, which is very much an offer and sale focused proposition, where we have Regulation S and Rule 143, which have a lot of sort of explanation and color and guidelines, we're kind of all on our own together, the banks, the law firms, and we're just trying to come up with a solution. And that's kind of why it's good to kind of have reminders like we're having today.
Yeah, I think that's a good point, Sebastian, that before 2008, there probably was no widely held agreement or practice on how to deal with these issues. And anyone can answer this question, Peter, Sebastian, Jonathan, anyone. I guess for someone who's not that familiar with this, as you are, can you give examples of some of the procedures in the memo and how they're more conservative than some of the practices that are potentially being done in the market, and where there might be some pressure points in the market now vis-a-vis the procedures suggested in the memo?
I'm happy to have a go at that, unless Peter wants to go ahead.
No, go ahead.
I think just to reiterate some of Peter and Sebastian's comments, this is to answer your question, Gary, so don't worry. The other reason that the procedures are important, and both Peter and Sebastian have alluded to this, is they are an attempt to articulate a relatively complex web of staff no action positions and varying interpretations of relatively limited legal focus. And I think the point that Sebastian made is, whereas from a 33 Acts perspective, there is an awful lot of law, there are an awful lot of rules. The extraterritorial application of the 40 Act is slightly less well travelled, and I think it's probably fair to say, and the other panelists may or may not agree with me, there has been less in terms of sort of staff pronouncements and certainly enforcement activity in the foreign funds area than we may have seen elsewhere. And so the real key here, and this is why the 2012 stuff is important, is to try and achieve some form of market consensus. And Gary, to answer your question as well, and this is sort of hopefully relevant to people, the 40 Act, there are sort of two limbs to the 40 Act that an issuer needs to be careful about in order to maintain an exemption from the Investment Company Act. Leaving aside the analysis, are we an investment company that needs to rely on an exemption in the first place? The next point is, well, as a foreign fund, which of our stockholders need to be qualified purchasers, or who do we need to count for the 100 or so people? And that's a sort of twofold analysis. One is, you need in a primary offering only to sell to US persons, and it's important to stress US persons, so unlike Reg S, you're actually looking at the US nature of a US investor wherever they are in the world. And here's a sort of fly in the ointment. The issuer, rather than those purchasers themselves, also needs to be comfortable that if initial subscribers for the issuer's securities, who are, for instance, qualified purchasers under 3C7, on sell, they are either selling to non-US persons or they are selling to other US persons who themselves are qualified purchasers. And what is perhaps a little unhelpful here is, as Sebastian said, the SEC said, issuers with stock that's tradable in just foreign security, foreign publicly traded companies, it's up to you guys, what is reasonable in your case to impose in terms of procedures. And so that's why we are where we are. The next point that I think becomes important, and actually does also go to your point, there are lots of different types of foreign funds. Not all foreign funds are equal. Where the 2008 procedures actually came from, sort of in my view, and this was a relatively, a relatively new development, is one of the reasons for listing funds outside of the US can potentially be because it would not be possible to list them in the US because the fund itself could not comply with the substantive requirements of the Act. So we had in 2008, particularly in Amsterdam, a number of big ticket US PE houses launching what were regarded as relatively novel products. And frankly, there was an awful lot of US interest in listing. It was essentially listing something, and in a lot of cases, a lot of these entities did actually end up in one shape or form back on the New York markets. But essentially, we were looking at US managers listing foreign funds, and 40 Act compliance was absolutely crucial there, because these were not sort of casual London listings of old school London investment trusts where it may be that some US person strayed into them. These were offerings that were deliberately being made by US managers and US investors being allowed to participate. On the other side, though, as I mentioned, there are an awful lot of non-US managed funds where the investment manager is in, for instance, the UK, that may want to attract US money. And what the procedures have to deal with is both categories. And effectively, the sort of are my initial investors QPs pretty easy, because you get rep letters. You make sure that you police you make sure that you police your roadshow process and whomever you talk to pretty carefully. There are a couple of nuances in there that we can get back to. The trickier issue, though, is what do you do in the secondary market? And the way that what the procedures are really aiming at is how solid are we that the people in this fund who need to be US persons, which essentially are the people to whom the issuer sells directly, the issuer who are in the US, who are qualified purchasers, the people in the US, and indeed the people to whom they transfer are QPs. Equally, if the issuer is encouraging secondary market trading in its shares among US persons, then you really ought to be making sure that if if the issuer or someone on behalf of the issuer sort of invites a US person to buy in the secondary market, they ought to be QPs as well. Now, where you get to on the procedures is what do you do to make sure that you are, that the issuer can work out in a publicly traded environment that those who need to be QPs are QPs. And this is where, Gary, you get some sort of sometimes some differences of opinion, sometimes people being a little stricter than others, and what it really turns on is a question of to what extent an issuer tries to be pretty dogmatic as to who can buy in the secondary market, and to what extent an issuer really sort of tries to make sure that it knows where its US placees are disposing of their stock. So the classic on this, and I know this is one that Peter perhaps would like to talk about, is generally speaking, if you sell to US persons in a primary offering of a company that's relying on 3C7, you obtain contractual commitment from those US persons that, generally speaking, they will only sell offshore in a sort of Reg S transaction to a person that is not known to them to be a US person, because essentially that, for the purposes of the 40 Act, washes clean that stock. Strictly, you don't necessarily need to do that. As the letter of the law, because if that qualified purchaser is selling to a US person who is another qualified purchaser, strictly that may be okay, so long as you get, you the issuer can be comfortable that the the transferee is a qualified purchaser. I think the other sort of points, the other points that come up that are worth mentioning for people on the call is a lot of the sort of other differences that you see in how the 2012 procedures depend as well very much on the settlement system and the mechanics of the markets of the primary listing. For instance, it is easier in some ways, and this is where the 2008 memo came from. If you were doing an offering in Amsterdam, the sort of Euroclear settlement system potentially is more amenable to sort of more invasive procedures, if you want to call them invasive, than say London, where the CREST system is trying to fiddle with anything that's going on in the CREST system is pretty much impossible.
Yeah. Thanks a lot, Jonathan. And Peter, I guess you may want to say something about that, but I guess this whole question of sales outside and to whom you sell to and making sure who's the QP is one of the areas where you would want to have some flexibility, but maybe not too much, I guess.
Yeah, not too much. And so the point that I would make, and I would stress what Jonathan said, but you have to get your U.S. investor representation letter from your QIB QP. You have to. So currently there is a trend in Section 482 deals and Section 4.5 deals under the 33 Act. There is a trend to put in a provision at the end of your U.S. investor representation letter that says, even if we don't return this sign to you, we hereby let you deem that we have given these representations. I have said publicly before, I think that's a bad idea under the 33 Act. But is it fatal from a no registration point of view? Well, it can't be, because there are plenty of people who live with that. You cannot live with that under the 40 Act. Under the procedures, and even before the procedures, if you're getting a 40 Act U.S. investor representation letter, a 40 Act, sometimes people call it a U.S. investor certificate, whatever you call it, you have to get it back signed, and the QUIB, qualified purchaser, needs to let you know that they're a qualified purchaser if you don't have another mechanism for confirming that. But more importantly, they have to agree to comply to the transfer restrictions. Whichever way you go with them, either, as Johnson said, my preferred approach, they will resell outside the United States, or they will resell to their qualified purchasers. But either way, you have to get it back for 40 Act purposes. That cannot really be a debate.
One of the reasons for that is that I think people look at 144A by analogy and think about how easy it is to do a 144A offering where there's not an Investment Company Act issue. For the last 31 years since 144A was adopted, the SEC evinced particular confidence in selling just to qualified institutional buyers under the 1933 Act in the circumstances where 144A is available. Pre that, and outside the context of 144A, at a minimum, getting the investor to acknowledge in writing circumstances of the trade, it was absolutely standard market practice. When you're not in a classic non-investment company 144A only scenario, at a bare minimum, you have to do what Peter said, and you have to get the investors' knowledge in writing what the restrictions are. Beyond that, it is not like 144A. The Investment Company Act exemption depends upon there being a reasonable belief that you only have QP investors. It is not enough to just say, I've only sold to QP investors. I know that's okay because there's the whole secondary market point that Peter referenced and Jonathan amplified. And so you have to take some other steps to get comfortable that the market characteristics or the company characteristics or what the investors do or what labels you put up in the clearing systems or whatever other procedures you apply is a reasonable basis to conclude that only QPs will ever trade these securities, or in the secondary market, maybe if you're a non-US fund, it's okay if the company has no involvement in secondary market trading for some other circumstances to rise, but outside of all of these extra procedures, not satisfying the Investment Company Act exemption.
I think the other point I'd just add on that, which really catches people out, somewhat, is the evidential burden that the 40 Act, maintaining a 3C7 exemption requires, does mean that you want to make sure that your paperwork is as solid as possible, because you may have your initial offering and you may think, be very comfortable that yes, we are only selling to people that are qualified purchasers. We, the company, know to whom we're issuing the stock, therefore that's fine. Where you find things can get horribly sticky is when the company then goes to do a subsequent offering at some point in the future. Both from a compliance perspective and from an opinion perspective, the lawyers involved are going to want to say, how did you qualify for 3C7 in the first place? How have you maintained that exemption? And it is therefore important to ensure that you have a very good documentary record of to whom you've sold in the first place, as Sebastian said. The other point actually that's also worth stressing, which is sort of also an element of, possibly partly an element of the procedures, you also need to make sure as an issuer that you are not doing anything in the interim equally that compromises your status as a 3C7 fund. This is the point about not encouraging US persons, to buy in the secondary market unless you are absolutely sure that they are qualified to do so. So again, the discipline of, as Sebastian says, of really being very careful as to whom all of your US investors are and to whom they sell, and being able to demonstrate that you have exercised that discipline is essentially fundamental to maintaining your compliance with the exemption.
Yeah. Well, I know that the procedures are intended to encompass some amount of flexibility, but does anyone know is there a more general market practice on these secondary market issues as far as how they're handled, or is it kind of people look at it on a more case-by-case basis? Does anyone know? Maybe there's no answer for that.
Yeah, I mean, it's not a great answer. It's not a great answer. I mean, the issue really, and I think, as practitioners, the point that you need to, the point that you need to make to issuers and managers of issuers, and there are sort of varying shades here of market practice as to what you can and can't do. But the real point is, from an ongoing perspective, you need to be very clear with the manager and the company that sort of any form of US marketing, whether on a sort of primary or secondary basis, needs to be treated with an awful lot of circumcision. You can't just go and talk to US investors to encourage interest in your stock. You do need to be a little careful as well, from a website perspective, etc., notwithstanding sort of 33 Act issues, also from a 40 Act perspective, that you are not doing anything that could be construed as sort of engendering US interest in your stock. And that becomes particularly acute. And Karen, I know you haven't said anything yet, but you'll also mention this from an Advisors Act perspective too. Post 2012, we've got a sort of an Advisors Act conundrum to address as well. But the issue, Gary, really, and particularly for an advisor, particularly for an advisor that is a US name, if you've got a US manager of a foreign fund, it is very, they need to be very, very careful about the sort of degree of US publicity for their non-US traded fund products.
And Karen, you're going to talk about Investor Act issues later, but before we move to a different part of this topic, I didn't want to neglect you. So if you want to add anything to what's already been said, please feel free to do so now, but you don't need to.
No, I've agreed with everything everyone said so far. And I'll save my comments for the Advisors Act section at the end.
I guess now we can very quickly, I think, maybe Peter or someone, I think that there may be some kind of non-US REITs and SPACs issues that might be relevant here, if you want to quickly speak about those.
Absolutely. So REITs and SPACs. So REITs, real estate investment trusts, are not necessarily investment companies. So an investment company, is what we're talking about here are funds. So we're not debating whether the issuer is an investment company or not. For REITs, for the most part, they are not investment companies because they don't meet the test, which is 40% in securities, because they invest in hard assets. They invest in real estate. And so for European purposes, REITs are funds, or are generally treated as funds, and are sometimes even though they're technically REITs, people call them real estate funds. And so it sometimes happens that U.S. securities lawyers uncritically build in 3C7 procedures to REIT offerings, either because that's what was in their precedent or because the bankers are calling them funds. And so I have seen, the 5 firms procedures applied to REITs, which is not necessarily the case. Now, a REIT can be an inadvertent investment company if, for example, it's a blind pool and it takes a long time to buy its real estate assets. It could theoretically be a transient investment company during that time. In the domestic practice in the United States, it is common for REITs to invest in mortgages. That is not common in Europe. But if you're in that scenario, there is a separate exemption for real estate investments, which is in the Investment Company Act, and you can use that separate exemption. But it's very, very rare that you would get to that stage in a European REIT, because simply on the balance sheet test, they don't invest in securities. So I'd like to highlight that because I have seen where REITs have had the 5 firms procedures imposed on them unnecessarily. And then for SPACs are also not investment companies. So the way that the SPAC is structured in the domestic practice in the United States is absolutely, under all circumstances, avoid investment company, the way that they're structured. One of the things that comes up is in order to not be an investment company, the SPACs will invest in U.S. government securities rather than other securities, but U.S. government, or keep their assets in cash during the trust fund period. For European companies that are SPACs, it's the same thing. If you don't want to be an investment company, you have to invest in in cash equivalents, or U.S. government bonds, not local government bonds, but U.S. government bonds. And so that's just something to be on the lookout. There have been a few SPACs in Europe that have voluntarily complied with 3C7 and with the 5 firms procedures. And there are a few different reasons for that. One of them is they wanted the flexibility to invest in local government bonds. And so they just said, okay, we'll be an investment company because we want to do that. And then the other one is a SPAC that wants to maintain the flexibility to acquire an investment company, might decide to be an investment company from the beginning. That is very much the minority. There have been a few listed in Amsterdam, but very few. The overwhelming majority of European SPACs structure themselves not to need to comply with 3C7.
But SPACs are the source of the most prominent discussion of the Investment Company Act of 1940 in the press, because we have seen a plaintiff's law firm bring an action against the Bill Ackman's Tontine giant SPAC for violating the Investment Company Act, among other things. And it was the both being covered in the press and then having, 49 law firms or some 47 law firms reply in a brief together, way more than the 5 or 6 firms that Peter was referring to. The industry came to rally behind SPACs and Bill Ackman and Pershing, but just more the principle to make the point that Peter's just said, that SPACs are not investment companies so long as you follow the basic principles that he just outlined. And so we are having the pleasure of seeing the Investment Company Act actually mentioned in news articles these days because of this case and this prominent instance.
And I had a quick question. I was thinking that when you said that some companies do voluntarily become investment companies, and I was thinking about the whole question of, monitoring and maintaining the QP distributions. Would that be more difficult in the SPAC? Because SPACs are, no matter what you want, SPACs are probably going to have a retail element to them. If that causes a problem for someone who does voluntarily become an investment company.
I think since it's happening offshore, it's probably like any other non-U.S. fund that's listed only outside the United States, so long as you've taken the steps to apply some version of the 2012 procedures. As long as the company is not out there flogging the stock in the United States, it's probably going to be okay to kind of fit within the framework.
I think we probably, looking at time, we should probably move on a bit. But if anyone has any final points they want to make, or recommendations, or predictions, or anything like that, please let me know. If not, we can move on to the next part of the agenda.
Gary, I would just to sort of follow up on do things really need to rely on 3C7 or not? I think the sort of practice point that I'd like to flag, and Karen may sort of chime in on this from an Advisors Act perspective, relying on 3C7 potentially does come at something of a cost for entities that don't actually need to rely on it in perhaps slightly roundabout ways. For instance, Karen will talk about sort of Advisors Act registration / reporting requirements for entities that perform advisory services to 3C7 funds. Although it's also sort of softened a little, there's also post Dodd-Frank the sort of Volcker rule impact of sort of bank-related entities investing in funds. So I think the one point I would flag is if you are involved in a REIT or a SPAC offering, it is worth making sure that the sort of 40 Act points and anything that may flow from the 40 Act points is sort of put out for debate pretty early in the process, because sort of simply deciding that you're going to sort of do 3C7 for prudential basis, on a prudential basis, or however you want to describe it, may have one or two sort of stings in the tail that are worth sorting out relatively early in the proceedings.
Thank you. Well, Jonathan, I think you'll stay on because we're going to go to the next item on the agenda, which are ERISA issues. So I thought maybe you could kind of give us a brief summary of some of those related issues.
I certainly, this is a light relief. ERISA hasn't necessarily got much to do with the 40 Act in some ways. I'm going to come back to a few more sort of 40 Act related points. But if you are selling foreign investment companies, or if you are involved, another wrinkle that you need to think about, which we wanted to mention because it's become a little more prominent in the market, is the US ERISA regulation, which for those of you who may be slightly less familiar, is essentially the regulation of US pension plans, needs to be thought about in the context of issuers that are neither properly operating companies, companies that essentially have a real business, nor are registered investment companies. And if we are relying on 3C1 or 3C7, we are not a registered investment company. Now, the key concern for foreign investment companies is if they accept ERISA money without any particular thought, then strictly they may themselves become subject to ERISA and all of the fiduciary obligations that ERISA imposes on people who are deemed to manage US pension plan money. And that is not something where a foreign fund or a manager of a foreign fund wants to be. Equally, the other point that is sort of relevant here is we are not just necessarily talking about knowingly selling money to ERISA plans. Equally, if unlike the 40 Act, if any ERISA plan buys in the secondary market, then strictly speaking, that can be a trigger for the ERISA fiduciary obligations. However, that said, the relevant regulation, a thing called the Plan Asset Regulation, has a number of exemptions to sort of plan status. One of which, and the one that sort of is normally relied on by overseas listed investment companies, is if essentially under 25% of the stock of the issuer. It's a bit of a more complicated test, but essentially it's as long as less than 25% of your stock is held by US pension plans, you do not need to worry about ERISA. Now, there are a number of ways in which foreign issuers deal with this. One is sometimes simply to say we will not allow in any ERISA money, no way, no how, never. And when you see the rep letters that we are talking about from a 40 Act perspective, you will also see reps in there that say, and we are not using any ERISA money, nor are we ERISA plans when we are coming in as investors. Or you may be able to allow some ERISA money in, but you then have to make sure essentially as best you can that less than 25% of the relevant percentage of your issued share capital, traded share capital, is held by ERISA plans generally, which requires some monitoring of your shareholder base going forward. What we've seen in recent years is actually, and without going off on a complete tangent, because most foreign funds aren't necessarily that attractive for investment for US taxables, we have actually seen a number of US ERISA plans deliberately targeting investment in foreign funds. Now, the Department of Labor, which is the US and the US regulator that actually sort of administers ERISA, is quite keen, and there are all kinds of other sort of ERISA rules about US ERISA plans investing in foreign assets, etc., etc. The Department of Labor actually, if it's ever going to enforce under ERISA, is more likely to look at US plans who invest in non-US investments rather than sort of going after these sort of foreign funds themselves. And there's been a bit of action probably a few years ago now that has sort of said, basically, if you are an ERISA plan and you are looking to invest in a foreign fund, you need to make very sure that that foreign fund will let you in. And so if you are thinking of attracting US money, and it may be non-taxable ERISA plan money, you need to make sure that, one, you are set up to take it in, and two, that you are prepared to negotiate in rep letters with ERISA plan investors that you agree that you will accept their money to come in. And ERISA plan investors are getting far more sophisticated about this, and what you will find on these kind of deals is that about the only US investors that try to negotiate rep letters on these kind of deals are the ERISA plan investors themselves, simply because they will require some form of affirmative confirmation, most likely from the issuer, that the issuer knows that they're in an ERISA plan and is okay with them coming in. And what you also tend then to see in the offering documents and also in the issuer's constitution is these days something that says no ERISA plan can invest unless the express consent of the company has been obtained. And that applies both in terms of primary offerings and also transactions in the secondary market.
Karen, do you want to add anything on ERISA or have anything to add on this?
I agree with everything Jonathan said. I just said that I want to mention that if the fund does wish to monitor this going forward, it's really worthwhile emphasizing to them how important that is, that they have to take this obligation very seriously. And there's a couple of nuances they need to be aware of. For example, the 25% threshold, which Jonathan mentioned, technically applies to each class of the fund. So if there are different classes, you have to look at it on a class basis, not on an entity fund level. And the other thing to keep in mind is that you need to take out of the equation any manager money that's put into the fund or invested in the fund. So it's really important to keep that in mind. If you're keeping an eye on monitoring that 25% limit, make sure you're aware of exactly how to do the 25% calculations, because the ramifications of going wrong on those are very, very severe. Okay, like Jonathan said, the manager will become an ERISA fiduciary. You'll have to comply with the ERISA requirements, and that's not something that funds are set up to do generally.
Great, thanks. Well, we can move on to the last subject on the agenda, which are issues related to the Investment Advisors Act. And Karen, I guess there might be implications here, including with respect to when an investment manager for a non-U.S. fund would need to register with the SEC as one question. Can you speak a bit about that?
Sure, happy to. Well, one thing that happened when Dodd-Frank was implemented was that the investment advisor registration regime was overhauled. And at that point, a new requirement was put into place requiring funds to look through at investors in the funds. Previously, an asset manager could rely on some fairly flexible exemptions from SEC registration. So if you had an advisor outside the United States to non-US funds, there's a lot of flexibility in exemptions. Under Dodd-Frank, there's a new requirement put in place that requires a manager to look through funds and look at the number of US investors and the amount of money that those US investors are putting in. So one thing that an asset manager should be aware of is that taking US investors into a fund could actually trigger the requirement for them to have to comply with certain Investment Advisors Act filing or registration requirements. So what does this mean if you end up being a manager of a fund that has US persons in it? There are several exemptions. The first one that people would usually try to rely on, first of all, is a sort of a de minimis exemption from all US registration requirements or filing requirements for investment advisors. And this is called the Foreign Private Advisor Exemption. Under this exemption, the asset manager, the advisor, has to be located outside the United States. It has to have fewer than 15 US persons invested in its funds or as clients. And one thing that's important to keep in mind here is that you don't look at this on a fund-by-fund basis. You have to look across all funds managed by the same advisor. So you have to aggregate how many US investors do you have in any funds managed by that advisor, and does the advisor have any managed account clients, direct US clients? And if you rely on this exemption, the total number has to be fewer than 15. Second, next thing is that less than 25 million in AUM can come from all of those US investors or direct US clients. So again, you have to have fewer than 15 US investors or clients, and less than 25 million in the aggregate coming from those persons. Another requirement is that you cannot hold the firm out in the United States to the public as being an investment advisor. and you can't manage a US mutual fund or a business development company. If you can rely on all of those, if you can fit within all of those conditions, you can comply with the foreign private advisor exemption. And under this exemption, you're exempt from almost every one of the Investment Advisors Act requirements. You still have to comply with some of the anti-fraud rules, but other than that, you're exempt from SEC registration as an advisor. You've heard my co-panelists talk about counting US investors, and a lot of the themes they've talked about carry through to the way that you would count investors in your fund. So for example, if you are marketing to US investors, you have to count them. If someone is an agent marketing on your behalf, a placement agent, etc., you need to count any US persons who are coming through the fund because of their activities. If someone is buying in the secondary market and you have no reason to believe that they're a US person, you don't have to count those people as US investors coming into your fund. One final thing that I often get asked about is what happens if you realize that someone bought the fund and then moved to the States. The SEC has stated that you don't have to worry about people moving to the States. The fact that someone has transferred from living outside of the US to living in the US doesn't make them a US person with respect to their holdings at the time they move to the US. But if you're aware that they are later on buying from the US, then you need to count them as a US person.
Makes sense.
So if I can go on for one more minute, what happens if this is the easiest thing to comply with. If you cannot comply with this, we need to either look at other exemptions or at SEC registration. Just to mention very quickly, there is another exemption, which is really a sort of a light touch reporting regime directed at alternative fund managers. And this is called the private fund advisor exemption. Now, an asset manager can rely on the private fund advisor exemption if they have no US clients other than a fund, like a Delaware fund, for example, and then they can have US investors coming into those funds, but you cannot have any direct managed account clients in the US. If you're operating from a place of business outside the US, you can take on unlimited assets into your funds from US persons under this exemption. But if you have a place of business in the US, you're capped at 150 million. And after you hit 150 million, you need to switch over to full SEC registration. So if you can comply with this exemption, you are what's called an exempt reporting advisor, and you have to file and report information to the SEC. Now, it is a light touch. You don't need to have an SEC compliance officer. You don't need to have a full-fledged SEC compliance program, but you do have to file information with the SEC to notify them of your status. You need within 60 days of your hitting the requirements to file. You need to update this information annually. And you should be aware that the SEC does have the right to conduct inspections of exempt reporting advisors, although they've said that it's not their intention, absent fraud or some red flag, they don't intend to inspect these managers. If you can't comply with that one, then you're probably looking at full SEC registration, but that's probably a topic for another day.
Well, I think you may have answered the question I was going to ask, Karen, which is, are there any other exemptions that people might need to look into and ask about? So you've already answered.
There's another exemption for venture capital advisors, but I won't go into the details on that right now. It's fairly complex.
Karen, can I flesh out? Sorry.
Yes, Sebastian, go ahead.
Thanks. Karen, can I just flesh out one point in terms of just seeing how you apply the foreign private advisor exemption?
Mm-hmm.
Talk about clients. How does that apply vis-a-vis, say, a fund that is advised by this non-U.S. advisor? So it's a non-U.S. fund advised by a non-U.S. advisor. Is the fund client, or if that fund is out there selling under 3C7 to say 50 U.S. QPs and then 200 in an placement, non-U.S. investors?
Technically, the fund is a client, but the SEC has said you need to look through the funds to the underlying U.S. investors. So, for this rule, you need to look through. So even if you're a non-U.S. advisor with a non-U.S. fund, you still have to look through carefully and see, are there any U.S. persons who've purchased that you reasonably believe are U.S. persons, either because you've marketed to them or your agent has marketed to them, and you need to count those persons towards the thresholds that I mentioned.
So for a fund that's doing a 3C7 placement to a big chunk of qualified purchasers, sounds like we wouldn't fit within that exemption. Is that right?
You could fit under the FISH exemption, the foreign private advisor exemption, only if you kept the AUM coming into the fund at less than 25 million, which if you're dealing with large GPs, you're probably going to go over that threshold fairly quickly. So then you probably are looking at being an exempt reporting advisor. That's correct.
Yeah. Karen, what I was going to add, see if you agree with this. I mean, from a sort of practice point, if you're actually involved in these kind of securities offerings, this is where we were sort of going earlier on. There is no sort of free pass on 3C7. And if you have a sales desk who say, oh, we just want to keep the optionality to sell to US investors, a point that you really need to flag and make sure that the manager is alive to is, the Advisors Act consequences for the manager, as well as this whole sort of 3C7 compliance. I mean, a couple of points that occur to me. If the manager of the fund is a US advisor in the first place, it is going to be registered with the SEC. Therefore, the point for the manager there, and this is a whole different topic, is how does it comply with its Advisors Act obligations in respect of this damned foreign fund and the disclosures on the foreign fund? I think it's probably fair to say, but Karen, I think you'll have a sort of better handle on this than me. If you have got a sophisticated non-US advisor that's already got sort of fairly significant interest in the US, it probably is already an exempt reporting advisor, or will have a registered advisor in its family. I think where I have seen the real sort of issue is if you have got a non-US advisor who thinks that doing a sort of a listed fund is a great thing and they haven't really got any US clients otherwise. You need to be incredibly careful in those cases if people start taking them on roadshows in the US to make sure that they've really thought through in advance the Advisors Act implications of taking US money.
Yes, absolutely. And once you hit the thresholds I mentioned, you have 60 days to get your filing in as an exempt reporting advisor. So it's very important to be aware of these. And if people doing the placement are keeping it flexible by operating it as a 3C7 fund, that's fine, but they need to be aware of the ramifications of taking on even one or two US investors.
Thanks.
And if you did 3C7 prudentially, you're one of these REITs or something like that, does that screw you under the Advisors Act?
If you've got if you're following 3C7 and you've got US investors coming in, the SEC has said yes, you need to treat that as a 3C7 fund, which would mean you need to report it on your form ADV if you are filing as an exempt reporting advisor.
Yeah. So in other words,
the advice is actually affirmatively don't do it if you don't have to. Don't do prudential 3C7 because it's not prudential.
My point, that is my point. My point, Peter, that is my point. And we haven't even got onto some of the other stuff. But my point is very much to my mind, there is in a way no such thing as prudential 3C7, or at least you might want to go there, but you make sure you do it with your eyes open.
Exactly.
And investors who come into the fund completely secondary, so no marketing from the fund or its agents, they just buy across London Stock Exchange. Are they going to count towards your 15?
The SEC has said you need to count people who you reasonably believe are in the United States, and you don't have to count people that you reasonably believe are outside the United States. So if you're complying with the procedures we've talked about on this call today, you should have a fairly good idea of who are the people who've bought directly from you or from your placement agent, and not know necessarily that people are coming in on the secondary market.
Okay, we're getting close to the end. So before we go to the Q&A, does anyone on the panel want to have any last words or any issues that we haven't discussed or reiterate anything that they said previously? Okay, good. I guess one obvious question that I'm going to ask and that is coming through is, if this was, originally done in 2008 and then revised in 2012, almost 10 years ago, do the panelists feel that there's a need to kind of take a fresh look at it and kind of see if it needs to be revised again in light of some of the things we've talked about as far as market developments over the last 10 years since the revision in 2012?
I would say no. I don't think there's any need for a revision. I think what we did in 2012 still stands and is pretty good, and is certainly should be either be followed or at least be the starting point. The one caveat to what I've just said is if we were doing it today, I think we would put investment advisors' warnings into it. That did not happen in 2012. And as Jonathan said earlier, it is possible that some people are not focusing on the Advisors Act as clearly as maybe they should.
Okay. But so you don't think, Peter, though, sorry, go ahead, Sebastian.
No, go ahead, Gary, sorry.
I was just going to say, if that's true, I mean, but you still don't think that we should just kind of revise it a bit to add the Advisors Act things and that might be another way to roll it out to the market again and remind people that it's there? And this is just a question. I'm not saying we should. This is a question for you and the other panelists.
It was very painful dealing with the five firms.
That's what I was afraid of. That's what I was afraid of, to be honest. Yeah.
So there is a risk of opening a Pandora's box.
Okay.
There is that risk.
Got it.
I would look at it as it's not only is it not broken, but we've all been in numerous situations since 2012 where market participants have been flexible about how to apply the 2012 procedures. It isn't a rigid construct that says this is exactly the way you do it. And so I think applying the judgment that transaction participants do, the principles, boundaries of the has worked fine, and we should probably keep the flexibility not to narrow things down. There doesn't seem to be anything particularly broken or non-functional in the procedures. And in different situations, Jonathan pointed out a U.S.-based manager. If you have a U.S.-based manager, you have to apply the 2012 restrictions more rigidly than you would if you don't. And so the ability to kind of choose where to sit along the spectrum of possibilities, I think, is probably the right way to go. And on the Advisors Act, I think it's way beyond sort of 5 or 6 firms. I think there are going to be a lot of different circumstances, and there isn't as form a set of principles that can apply across the whole range of managers and advisors. And I think we probably not want to get too scientific about how to tell people how to manage their affairs on the Advisors Act front.
Okay, great. Makes sense. And I guess this is a question for AFME kind of, but for all of us too. Since this is an important issue, what should we be doing? Maybe this is more for me, actually. What should we be doing besides things like this webinar to kind of increase awareness of the procedures and increase kind of use of the procedures and just for people to start thinking about them more as they kind of approach some of these transactions? Even if it's for me, if anyone has any suggestions on that, I'd be happy to hear them. If not, I'll have to think about it a bit more.
Well, holding panels like this are definitely the way to go as far as raising awareness. The 5 Firms memo is already on your website, so make sure that it stays on your website. And I think that's it. I think maybe having this panel maybe annually or biannually.
Yeah, or other subjects, something like that. Okay. Well, it looks like we have 1 minute left, so I'm very very happy that we were able to do it within the time allotted. Thank you all for coming, and if no one else has anything else to say, I just say thank you for coming. I found it very interesting, and I hope the audience did as well. I can certainly say that I learned a lot about this subject. So thanks, everyone, and see you on the next one. Take care. Everybody have a good day.
Thanks.
Thank you
very much. Bye-bye.